All right. Hi, everybody. It's Friday, and you know what that means. We are doing our weekly Karen Reed trial roundup with our legal analyst, Katherine Loftus, who joins us every Friday to talk about the case. Hi, Katherine.
Hi, Christina. Thanks for having me.
Of course. So, both an eventful and also slow week. Let's just start by refreshing everybody's memories of where we are. So, it's Friday, April 11th, and as of now, 16 jurors have been seated, but jury
That's right.
selection is not complete in this case.
That's right, which is the opposite of what we expected. Most of the week, I think everyone anticipated that, as the court indicated, once we got to 16 jurors, that they wouldn't go another day to get more, which is, I think, interesting. And maybe some things can be gleaned from that, even though those are four extra jurors, alternates, and you only need 12 when ultimately you go to deliberation after the trial is over. But given the fact that this is going to be a lengthy trial, even if it's a little bit shorter than last time, it's likely to last, somewhere between 6 and 8 weeks, all in. I think probably the court and even the parties thought it was probably best to come back one more day just to make sure. As you've reported, we've lost, I think, three jurors throughout the process at this point.
I think at least three. Yeah.
At least three. So, there's a part of me that thinks you wonder if you would potentially lose jurors over the weekend if new information came out, or, there were, some other circumstances that would cause the juror not to be able to sit. So I think they're probably erring on the side of caution to make sure they get through the weekend, don't lose anybody else. And then if they can, grab an extra one or two jurors next week, that's probably the safest bet, to have as many as possible once we start actually taking evidence.
Right. And just so our viewers know, we in the media and in the public, we never get to know why a juror is excused. Sometimes it's like personal scheduling reasons, and other times it is like maybe something pops up on social media and they, maybe no longer would be a good juror. So we don't get to know why.
Right. So we're really left speculating. I mean, it's a little bit different in this case because they have permission from the court to be able to take the list of the jurors' names to do independent research. That's normally not what happens in a case like this, but given the level of publicity and, the concern about people sneaking on the jury, whether it's someone for Karen Reed or against Karen Reed, what people refer to as stealth jurors. I think all the precautions are being taken. But like you said, we don't know. All of the jurors who were ultimately sat and then dismissed could be simply, personal reasons, or they could all be something that came up in the research outside of court. So
Right.
it's tough to know.
And you and I have talked about this, but there's not always time on TV to get into this. So you mentioned this independent research being done. Can you talk a little bit about what's different in this trial as far as like lawyers being able to get the list of jurors and research them?
So normally in a jury trial, what happens is you don't know what the names of the jurors are. You don't know what towns they live in. You don't know any information before you go to court that day. Quite literally, you will get a stack of paper that looks like this, and each individual paper will have the questionnaire from the juror with their number in the top corner. And that's what essentially you have to go off of. But of course, this is not a normal trial. And so what normally would happen is you would take that stack of papers, you would go through the process. Each individual juror goes up to sidebar, you have the voir dire, things like that. Obviously, in this case, we have the individual additional questions, that it was the two-page questionnaire, and then the third page relative to the publicity questions that the jurors all filled out each day. And
Mhm.
then typically you would return everything at the end of the day, and you wouldn't get an independent list of who the jurors were, or what their names were, any identifying information, anything like that. So what the defense has been asking, motioning the court, is for the list of jurors at the end of each day so that they can then do their own independent research. Normally, this isn't a standard request, and it's not something that we generally have to be concerned about in most cases that are happening every day in the courts in Massachusetts, and I'm sure in other jurisdictions. We're not really as worried about people sneaking onto the jury, or falsifying information or answers in the questionnaire. But because of the intensity surrounding this case, and really sort of the entrenched beliefs that people have, the court did allow this extra step of sort of a precautionary measure. So like with most of everything else with this case, it's not the norm. It's not the norm, but I think it's to protect the sanctity of the not only the jury system as a whole, but this particular jury here. I think it makes the most sense for all the parties to have as much information as physically possible to make sure that the jurors who are on there are who they say they are.
Right. And to have those extra jurors seated. Like I remember talked to you about this week. For the first trial, at the end of jury selection, there were 19 people seated. And over the course of the trial, by the day of closings, there were only 14 left.
That's right. That's right. And
So,
so, because you always, when you have this length of a trial, there are always going to be things that happen and come up in life. And so you want to have that little bit of an extra buffer. And I think that's probably where the court's head is at. They're thinking of the last trial, how many they started with, how many they ultimately ended up with. And they can't afford to lose 4 or 5 jurors. They can't, if there was ever a world where, 5 people for some reason or another, then another mistrial would have to be declared. So it's really better safe than sorry. The more we have, at the end of the day, 12 will deliberate. We'll have a number of alternates. Does it matter 4 or 7? It probably does. I think it makes both the court as well as the Commonwealth and the defense, I think, more confident that at least they'll get all the way through to a deliberating jury.
hmm. Actually, yeah, we're going to be weeks in advance talking about this, but let's talk about the way that process happens. Because I get
Sure.
this question every time, and I think there's a lot of new people who are following this trial now. We always say 12 deliberating jurors and the rest are alternates. At this stage in the game, we don't know who's who. Everybody hears the case as though they are going to be a deliberating juror.
That's correct. So though that's statutory, that the alternates don't get picked until the very end, basically until the close of evidence when the judge is sending out the jury to deliberate. And the point of that is so that everybody pays attention the entire time, right? You don't know whether you're going to be deliberating. And, if you think about if they named the alternates in the beginning, what is the likelihood that they would pay as close attention to every witness or every piece of evidence as if they thought that they were deliberating? So what will happen is, say we have 18 jurors, we will go through the entirety of the case. The case will be presented by the defense, it'll be presented by the Commonwealth, and then when the court ultimately sends the case out to the jury, there will be 12 out of the number of jurors chosen, and those are done at random, and then the foreperson is chosen. So the purpose is really to protect, again, the nature of jury deliberations and to make sure that everybody's really paying attention to the whole case.
Yeah, just because people are following the details of this case so minutely, and there's been so many allegations of corruption or bad behavior. I went back and I watched the alternate selection from last trial yesterday just to see
Yeah,
kind of how it worked. And then I also asked the clerk about like the order in which they seat people. So I just want people to have this information. The clerk told me that people are seated in their juror seats, like seat 1, seat 2, seat 3, seat 4, in the order they are picked during jury selection. Um,
correct.
Unless there's like some reason, like last year there was a woman who was overheating, so she had to be closer to the air conditioner, and people get moved for like logistical reasons.
Right.
Then at the very end, like you were saying, the judge picks the foreperson before the
Correct.
alternates are selected. So do you know why, or is it standard? Like I know in Massachusetts, judges pick the foreperson.
That's just standard in Massachusetts. The judge always picks the foreperson. Um, I don't know. I'm sorry to tell you, I don't know what really the intent behind it was, but
Yeah.
that's always been the way it has been. So it's not anything, there's a lot of questions that people always have about how the alternates were selected, how the jury foreperson is selected. But I think it's important for people to sort of take note of and remember that that's the way it goes in Massachusetts. It's not
Yeah.
that Judge Canoni picked a certain person and in any other case she wouldn't do it this way. She, not only picks the alternates in the manner in which normal alternates are picked, she also picks the foreperson in a manner in which the foreperson is usually picked. So that's how it usually goes, that the alternates are picked at random and the judge picks the foreperson.
Yeah, she picked the foreperson as the juror sitting in seat number 1, which I will say for I know that that's not necessary, but for every trial I've covered, that's been the case. The judge usually just picks the person in the first seat to be the first.
Yeah, I mean, there's a lot, we can all read into it. It's not a decision that they have to explain to us why they make it, so there's a lot of, can be speculation about, sometimes they're probably not going to pick somebody who, look like they were falling asleep half the
Fair.
time, right? Like
Yeah.
they generally tend to pick somebody who looks like they at least were paying attention. And really what it is you're picking somebody not to, the foreperson's job is not to guide the jury in a decision. It's not to lead them one way or the other. It's just to basically be the intermediary to relay information to the court. So they tend to pick people who probably fit that role in their real life.
Okay. And I'm trying to think if there's anything else jury selection related. Oh yeah, just to go over the scheduling, because we talked about this, they're going to come back Monday. The plan originally, so today's Friday, there's no court.
Right.
That was always the plan. The plan was also to have no court on Monday, assuming that jury selection had wrapped up. But they did, and this is based on my observation, they did go and interview and have voir dire with every person remaining on Thursday. I think they just
Okay.
didn't seat anybody past 16.
Right.
And so then they decided to add Monday back to the schedule and continue with jury selection on Monday. So
Right.
openings will be next week, but I guess we don't really know what day.
Right. I mean, and I think I don't know if they have relayed to you or if you have any other information, if they have a set number in mind over 16, whether they want to get to 17, do they want to get to 19?
18.
So I think 18 is where they are. So, theoretically, we could get to 18 on Monday, if not, probably by Tuesday. But again, I think it probably makes the most sense, given how many we lost last time. I think the more the better, just to be on the safe side.
Yeah. And this is a question I asked you this week and we included on TV because it was a viewer question, but I want to ask you today too. How does the court make sure that jurors are protected from outside influence or media in this case?
So it's difficult. There's no direct sort of protection from of individuals who serve on the jury, on their own. They go about living their life as normally as possible. I expect what happened the last time will happen this time as well, which is that the jurors parked someplace else and then they were bussed in, and then basically escorted into the courthouse. And that's part of the issue relative to the buffer zone and the expansion of it from last time, because one of the main concerns about the jury is that they're not inundated with outside information, and really the concern is that because of the level of attention on this case and how many people last time were protesting outside, there was a juror affidavit that was submitted to the court that they could hear the chanting and protesting. So the court has taken steps in expanding the buffer zone to try and to protect that. Obviously, we've talked about in different ways that Norfolk Superior, the actual courthouse, is a very old courthouse. It's built in early 1800s, and so there's sort of this idea that, is there another alternate means to sort of kind of push them away, put them in someplace a little bit more quiet, but the physical building really doesn't allow that. So I think the court is trying as best possible to make sure that the jury is not subjected to any of that, when they're entering the courthouse. But ultimately, there's some of it that's out of the court's control.
Right, right. Okay, I want to switch gears unless there's anything else jury selection related that's on your mind.
I don't think so.
I don't know how much more we could
I
talk
don't know.
about.
I'm jury selection. No,
Yeah.
I'm ready to go.
Right, I
Let's
know.
get
It's been
to
8
openings.
days, 8 full days of jury selection.
Yeah,
We're moving
yeah.
So the other thing that happened this week is which we had known last week, that Karen Rita petitioned the US Supreme Court, so the highest court in the land, to hear her case.
Right.
And then this week, the court put her case on the schedule for April 25th, where they may or may not decide whether to take it, but then also denied her motion to stay. So denied her request to basically put a stop to her current state trial.
That's right.
Yeah.
So basically,
expected that, right?
yeah. So what has really happened is the Supreme Court is the last court of resort for all cases. Obviously, it started at this is the motion to dismiss, which was denied by Judge Canoni, affirmed by the Supreme Judicial Court. affirmed by the federal district court, affirmed by the federal First Circuit Court of Appeals, and now they're going to the Supreme Court. So they filed, Karen Reed's defense team filed two things: a motion to stay, as you said, as well as the appeal of the lower court's denial. Judge Ketanji Brown Jackson denied the motion to stay. So what that means is basically a motion to stay a proceeding essentially is asking the court to stop the lower court's proceedings. So Karen Reed's team was asking the Supreme Court to order Judge Canody to stop impanelment until they were able to decide whether they were going to accept the case or not. Justice Jackson denied that. So the case obviously is still ongoing, impanelment continued. At the same time, she referred the case for conference on April 25th, I believe it is. And what that means is, so the Supreme Court meets generally 2 days a week, and they conference. So they conference cases that they have heard already in oral arguments, that they have briefs on, as well as the cases that have been requested to be heard by them. So we call them petitions for certiorari. And they discuss whether they want to accept that case or not. Now, it's important to note that there is approximately 8,000 cases per year sent to the Supreme Court for review. And of that 8,000, I think it's someplace like 80 or 90. So it's a very small, 2-3% of the cases that they take. And what they will do on April 25th is they will conference this case as well as others. And if 4 or more justices decide that they want to hear the case, then that means they accept it. So that they grant cert is what we call it. I don't think that is likely to happen. And that's because the case law is pretty clearly not in Karen Reed's favor. The precedent is pretty recent. There's a case called Bluford versus the state of Arkansas, which is a very similar fact pattern, although maybe a little bit more egregious than Karen Reed's, in which Chief Justice Roberts wrote the opinion. So what they would have to basically argue to the Supreme Court is you have to overturn your own precedent that you just set 13 years ago, and the likelihood of that happening, in addition to the fact that 4 lower courts have all agreed. I think it's always been a long shot, but ultimately that's our right to appeal all the way to the highest court in the land. But I wouldn't expect much from it.
Right. And I should have said this at the beginning, but just to rehash what the argument is that's gone through every court so far is that Karen Reed wants 2 of her 3 charges thrown out, arguing that jurors acquitted her.
Right. So the argument is all based on a double jeopardy clause. And what double jeopardy is a constitutional right that you're not tried for the same charges twice. So if you are theoretically acquitted of counts, if she was theoretically acquitted of counts 1 and 3, then she could not be tried again on double jeopardy grounds. So the question is, did the jury decision constitute a verdict? What the courts have all said at multiple levels is that no, that in fact did not constitute a verdict, because the rules require for a verdict to be considered valid, it has to be returned in open court, which it obviously wasn't. So the question really is for all of the courts that they have petitioned to is we want the defense's argument that the jury's decision, which was not returned in open court, still constituted a verdict and therefore should qualify as an acquittal. And if it was an acquittal, she should not be tried again on double jeopardy grounds. But again, the legal precedent is not in their favor. And, it's one of those things that I think most people feel, rightfully so, that it has kind of a morally wrong feeling to it, that if 12 jurors decided she was not guilty on 2 of the charges, she should get the benefit of that. The problem is that the law is rule-based, and the rules require that in order for that to be considered an actual acquittal, it has to be read in open court and affirmed, and it wasn't. So that's their argument. I think it's unlikely to succeed, because I'm not sure how much legal merit it has, but that's their pitch.
Right. I have one other major topic I want to get to with you today, which is actually for a story I'm working on today, since there's no in this case, which is about Karen Reed talking to the media, which you and I have talked about many times, but lately, so just to update any of our viewers who don't know, there's a gag order on all attorneys involved in this case. So Karen's lawyers, prosecutors, nobody can talk to the media.
Right.
Karen can. That doesn't apply to her. And so every day after court this week, she has spoken to all of us reporters outside of court. She's answered questions about the process and talked about her own feelings about the case. She's done this documentary that came out last month, I think. She did interviews with national news organizations. She's been out there a lot. And just yesterday, another Vanity Fair article came out where Karen Reed also did an interview and gave multiple quotes to them. So my first question for you is this typical for somebody on trial for murder to be so outspoken?
It's not. It's not typical for any defendant to talk. Um, it's about as unusual as it comes, particularly somebody who's charged with such a significant crime. We're not talking about a simple assault and battery or something, a misdemeanor. This is a case that's very, very serious. Second degree murder charge is a life felony. It, it's, I think it's sort of goes to the intrigue about this case, that it is in fact so different, that you have a criminal defendant who's on trial for murder, who is not only, as you said, speaking to multiple publications, doing on camera interviews with news organizations, with documentary series, but also giving print interviews. And then on top of it, she has essentially become the spokesperson for the team outside, because as you stated, they're under a gag order from the court. So, I think it goes more to sort of what the public perception of this is. I'm not sure that that her speaking helps her in any way in court. In many ways, it's harmed her more than helped her. So it's an interesting kind of dynamic, because um, her using her voice to advocate for herself, I think, has garnered support for her publicly, but it also has likely put her in a position that her statements can be considered inconsistent in the eyes of the law, and will likely be used against her by the Commonwealth. So it's really kind of a fascinating, as an attorney, to wonder what is the strategy behind her being so public and so outspoken, and what is sort of like the risk analysis of it, of whether it's effective or not.
Yeah, you have given me the soundbite so many times now, but it's such a good explainer, which is, we know at this point, based on court filings and statements made in court, that the new prosecutor, Hank Brennan, plans to use some of Karen Reed's media statements as evidence in her second trial. Can you just talk about the risk? Like, I think you kind of gave us the risk of talking to people breakdown the last few times we spoke.
But so, it's generally when people think you have the right to remain silent, that goes to when you're in a police investigation, if you're in a room at the police station, and it's what we see on TV. But what's important to note is that, particularly when you're charged with a crime, that anything you say as a criminal defendant, anything you say to anyone, whether it's a police officer, whether it's a reporter, whether it's a civilian, anybody essentially outside of your attorney, can and likely will be used against you, particularly if what you're talking about is substantive to the case. And much of the conversations that Miss Reed has had with the media really go into the nitty gritty of her sort of perception about what happened that morning. And the problem with that is that while she's able to tell her side of the story, that then enables the Commonwealth to take all of those statements and use them, present them to a jury, and show that um, her recitation of the facts has changed over time. And you never want to give the government ammo against you. And that, I think, is quite interesting, that in a way, the strength of the Commonwealth's case will have gotten gotten stronger because of her giving interviews. So this is why it's generally not advisable. And I understand the sort of PR perspective and getting the public support behind her. But ultimately, if it does not help her in court, I'm not sure that in the sort of long-term analysis, whether it will have been the right move or not.
If Karen Reed were your client, what would you advise her to do media wise?
I would just say no talking. I mean, listen, I understand that, from her perspective and from her team's perspective, they believe she's being persecuted and they believe she's, a victim essentially of a criminal conspiracy. And so I understand, and I think most attorneys understand that there's nothing more that clients often want to do is tell their story. But oftentimes when they do tell their story, it ends up getting them in more trouble. And so, from my perspective, I would say maybe save it until after we have an actual verdict. If you want to tell your story, do it then, because ultimately, I don't think that it's persuasive in any way or in any way helpful to her case.
So then I think my last question, which is the other obvious one, is if Karen Reed feels so strongly about telling her story, which she does, she literally told me yesterday that she does, why not testify?
Well, I think because she would be in trouble if she testified. I mean, realistically, I think that there are too many inconsistencies in her statement. I think that I don't think she would do well under cross-examination. And that's really the sort of the crux of it. We've heard her say that her speaking out is her, ability or version of testifying. Um,
Right.
but is it really? Because what testifying is not only telling your story but also being subject to critique from the other side by that. So what we're hearing, whether it's in Vanity Fair or whether it's on HBO, what we're hearing is her version of events, right? Without any question, without any pushback. And I
Right.
think she could get on the stand and tell that story, and I think it would be picked apart pretty significantly if by a good prosecutor, specifically somebody like Hank Brennan. So I think that anybody, watching this, any attorney knows, and her team obviously knows they could never put her on the stand. There's too many sort of spots for her to get caught up in. But this way, she is sort of able to present it as if she's telling her side of the story. So I mean, it's an interesting strategy for sure.
Yeah. Anything else I didn't ask you about before we wrap up today? It was a long one. Sorry.
No, no, no. Hey, you keep asking me. I'll keep chatting. No, I'm just
Okay.
looking forward. I mean, I think it'll be interesting. Hopefully, we get the final jury on Monday, and then get to opening statements. So I'm looking forward to seeing. I think most are. Alan Jackson is going to be given the opening this time instead of David Unetti, so it'll be interesting to see sort of what's changed up there, and really to see, and for many people to see Hank Brennan in action outside of just a motion in front of the court, but with live witnesses. So um, I think it'll be an interesting one.
I think so too. So just a reminder to our viewers, we do this at the end of every week, wrapping up what's happened that week and looking ahead to next week. So, Catherine, thank you as always,
Thanks for having me.
and we'll see you later. Bye.
All right.